Good morning, everyone. Welcome to the Utah Court of Appeals. I'm Judge Ryan Tenney. I'll be chairing today's panel. Please be joined by Judges Mortensen and Luthi. We're deliberating on several cases today. We're holding an argument on one of them. I'm not going to try to pronounce the names without help. How are we going to pronounce the names?
Krajeski.
Krajeski.
Sorry.
I'm not sure I would have gotten it correct. So we're here to hear argument on Krajeski versus Krajeski. If counsel could start with your appearances, we'll start there.
Julie Nelson and Aaron Harris for David Krajeski, appellant.
You're welcome.
And Your Honor, Bart Johnson on behalf of Tammy Krajeski. Thank you.
I think you've both been here before, but just to make sure the ground rules are clear, we allot 15 minutes per side per argument. There's a clock on the podium. It works backwards. Per our custom at this court, if we're asking you questions, when you've hit zeros, don't feel like you need to ask our permission to answer the questions. But if there are no pending questions and you're at zeros, it's time to stop. Are there any questions before we begin?
No.
Okay, if not, we'll hear from Ms. Nelson.
Good morning, Your Honors. May it please the court, Julie Nelson for appellant David Krajeski. The background principles are pretty clear here, and happily this court just laid them out very nicely in Thorup versus Thorup 2024 UT 93 in July. It says, as many cases have before, that married persons have a right to keep their separate property separate. That's important because otherwise independently wealthy or retired people, among others, would be discouraged from getting married at risk of losing all their separate property. And in this state, that doesn't seem to be one of our policies. There's three ways to combine separate property into marital property: commingling, contribution, and equity. But underlying all of those is intent. That comes from Dahl. What did the parties say and do to show whether they intended to convert David's separate property, but apparently not Tammy's, to become marital?
I'm glad that you bring up Thorup versus Thorup, because the briefs say that the standard of review on this issue of separate versus marital is for correctness, and that's not what Thorup says.
You know, I noticed that as well.
Yeah,
Yeah.
so I want to ask, Thorup says district courts are in the best position to determine whether property is marital or separate, and we defer to their findings in this regard unless clearly erroneous. I went down, just so you know, a rather deep rabbit hole for actually more than one day. And it appears to me, I may be wrong, I haven't completed my dive, but it appears that our court maybe has said two things in contrast to each other, not thoughts that can hold the same place at the same time. In other words, we may have been talking out of more than one side of our mouth. Do you think that's the state of the law? Or do you think it's resolvable?
I think it's resolvable. I think we have to make sure that the trial court has correctly applied what the law means, right? What the law says about what constitutes commingling in this case, or contribution in other cases. And if we follow that law, then we are in the abuse of discretion land, where we're evaluating the factual findings against the record. That's how I think we
Well, in that same
reconcile
paragraph I was reading back in Thorup, it says that we generally defer to a district court's categorization. So, I understand what you're saying. We have plenty of cases that stand for the proposition that if a court misapprehends what the law is in making a discretionary decision, then that decision, by definition, is an abuse of discretion. Is that what you're getting at?
Yes.
Okay.
And that's how we've described the standard of review on page 3 of our brief, is that sort of tiered approach. We're looking first, did we apply the law correctly? And if so, then did you abuse your discretion? I think we have to reconcile it that way.
I think what you're saying, and correct me if I'm wrong, is that the court makes a determination of whether it's separate and marital and then decides from there where to go, but that decision of whether it's separate and marital is reviewed for correctness, or am I misunderstanding?
Yes, that's my position. And that was my position before Thorup and is still our position.
So what part of it is discretionary?
Well, I mean,
On a commingling question, I mean, just to make sure that my question is framed correctly. When we're reviewing a district court's decision that property was or was not commingled, what I hear you saying now is that that's a legal question because it sort of turns on how to view the statute. So what part of it is discretionary?
Well, so for example, like let's talk about tracing. So we know we have law, and Thorpe even says that if it's inextricably commingled, then you can't do anything, right? And then if it's traceable, it's not commingled. If it's inextricably intertwined, whatever it says, then and it's not traceable, then it's commingled. So then you've got the trial court who's in the position to decide whether it was in fact traceable and whether it was inextricably intertwined.
So that latter part, whether it was traceable or not, is discretionary or it's legal?
Discretionary.
That part's the
That's a
discretion.
fact, that's a finding.
That, I would say that's a factual finding. Yes.
Okay. So then what part is the discretionary part?
I'm sorry, what part's the discretionary part?
Yeah, what part's the discretionary part then? Because it
No.
feels like the traceable part is factual. It feels like the application of statute is legal. So where's the wiggle room that the court has in terms
Well,
of
so
its
whether it's
discretionary power?
traceable and whether it's factual, that would be the discretionary part, right?
I'm asking you.
That would be my position, right,
Okay.
that if it's traceable, whether it's like a factual decision, that would be the discretionary decision.
And
Well, sorry.
on traceable specifically, then one of the legal questions would be, are we applying an accounting sense of traceability versus a legal sense of I mean commingling, I should be saying commingling. But what we mean by commingling is a legal question.
Yes.
As far as our statements that whether property is marital or separate can turn on intent, isn't intent a quintessentially factual question? And would that be, how does that fit into this
Well,
framework?
that may be here, but I think that in this case, turning back to this case, the intent really isn't disputed. Both parties testified, put in their affidavits, and testified that they always intended their separate property to stay separate. Tammy's record sites are R1145 and R1315 to 16. She said in her affidavit, I wanted to protect my separate assets.
So before you keep listing that, let's assume that the intent was to keep them separate, but can you, what do you do if the intent appears to be to have kept them separate, but actual commingling happened, and there's a finding of commingling juxtaposed with undisputed intent to keep it separate? What do you do?
Well, we need to analyze, okay, so what are the facts that are underlying the intent component, right? What was their intent? And what actually happened in the commingling, and does the commingling analysis follow Utah law? So if I can turn to, like, for example, the DJK operating account. The DJK operating account was always DJK was David's separate property, and the operating account belonged to DJK. But David would take draws from it, and Tammy alleged that he sometimes reduced the draws that he took from it. Well, Brown tells us as a legal proposition that if that happens, that is not marital.
Well, Brown focuses on what it calls the flow, right?
Correct.
Right. Okay.
One-way flow, and we have the exact same setup here in DJK. I mean, that case is almost on all fours. The flow was going into the estate, and Mrs. Brown had argued that Dr. Brown had taken less draws than he did sometimes.
Can I ask you, let's change the facts of our case just slightly here, that prior to the marriage, that instead of taking draws, for whatever reason, he decided to take the money as W-2 income and took it on a fairly regular basis. And then at some point in the marriage decides to stop paying himself and just lets it accumulate in the account. Does that change it at all?
Well, so.
I understand the flow is not the same as Brown, because the flow would be, it got paid to him and he turned around and stuck the money. You admit that if he received the money in a joint account and then sent the money back into the DJK account, that would be commingling, right? All
Yeah.
day long. Okay. So under the hypothetical of the W-2, does that change anything?
Well, Dr. Brown had both. He had a W-2 and he had draws. And they still found that all of the dental practice and its money remained separate because the money was just going that one direction. Now, what they found was that any of the money that left the separate account and became marital money, that had been commingled, but it never went back to capture everything that had come before. And we don't have that W-2 income scenario here, so
Right.
we're only looking at draws. So back to the standard of review question, we have a legal principle that sets out what governs the DJK operating account. And so under the law, under a legal analysis, the DJK operating account under Brown has to remain legal. When we move to talk about the Morgan Stanley accounts, there's 4 of them, only one really has any money that talks about,
Before you get quite to those, can I keep you on the DJK
Sure.
account, just briefly? One of the things they've told us in response is that there's testimony, I believe from your client, that he put in 20 hours a week during the course of the marriage. I'm gonna use the wrong verb, but sort of dealing with the accountants and dealing with the issues. Why, one, did he testify to that? And two, if he did, why doesn't that matter in terms of this analysis?
Okay, so that fact really is more relevant to the Wells Fargo accounts, but we can talk about it now.
Sure.
And what we're going to say is that he never testified to it. It was, it's in Record 80. It never came up at trial. They never asked him about it. They never talked about it at trial. And we know that Tammy testified that she had to stop working 10 hours a week because it was interfering with their lifestyle. Now, let's keep in mind also that this is a retired person, a mostly retired person, or an entirely retired person who's just managing these assets. He's not really under any obligation to say, work to support the marriage. He's independently wealthy. We don't have any case law that says if you're independently wealthy when you get married, you're not allowed to spend any time managing your assets anymore.
But if he's spending time managing the assets and that's contributing to his ability to receive funds from them, why isn't that equivalent to work that's producing the income that's coming from those funds?
But
What's the
Dr.
difference
Brown
there?
was working. We know that Dr. Brown was working. It still meant that the asset itself remained separate, and the money that's coming out of the asset becomes marital. And we agree, the same as in Brown, money that came out of the DJK Properties account, we're not talking about that. We're talking about the money that was still sitting in the DJK Properties account. So, I mean, Dr. Brown was actively working, right? He was practicing dentistry 40 hours a week. So that was never part of that analysis.
Seems like you've given us a 2-level response. The first is that you would put it in air quotes, probably the evidence on which the finding was based never came into evidence during the
Absolutely.
trial. And that if we were to agree with you there, we don't need to analyze the rest of what the contrary evidence would
Yes.
be. But if we were to say, no, that declaration was properly considered, then we could go on to saying other things. Is that correct?
Yes.
Thank you.
I know you're zeros, but I know the chair.
Wow, that went real fast.
Yeah, the chair's not gonna hold these against you on your rebuttal, I assume, since I'm gonna ask you a whole bunch more questions, if that's okay.
Sure, I have a whole bunch more to say.
In your brief, your heading on this issue, not alimony, not the attorney's fees, is that the court erred legally in its classification of David's premarital separate property, correct?
Yeah?
Okay. That doesn't feel to me as a challenge to factual findings. Are you accepting the factual findings as stated by the court and saying that they were then erroneously applied under the law? Or are you saying there are factual findings that are clearly erroneous?
Well, I think we've got to work down through the accounts, can we? So on DJK, the DJK operating account,
First, give me the 30,000 foot. Are you saying, I think you're about to tell me that you're challenging both.
yes.
Okay, go ahead.
So on the DJK operating account, in my view, that's a legal challenge. Like, the court failed to apply Brown. Out. On the Morgan Stanley accounts, we know there that $1.3 million of it was inside the account when they got married. And we have all kinds of cases, especially I would point you to Kiter, 2010 UT App 169, paragraph 28. We disagree with the trial court, however, that the entire value of the property should be divided equally without first subtracting the value allocable to husband's clearly demonstrated premarital payments. The post-marriage commingling of funds does not somehow relate back to convert these premarital separate payments by husband into marital expenditures. I think we're looking at that same thing on the Morgan Stanley accounts, at least as to the first $1.3 million. Now, there's only $1.4 million at issue, so 13/14 of it were sitting in there when they got married. That has to be David's, and I would say that's a legal analysis, not a commingling analysis. What happened next?
Well, can I stop you there?
Sure.
In the body of our domestic jurisprudence, not asking about this case specifically, but in general, if you have an account that has monies in it and their commingling occurs, the phrase that's used is that the fund loses its identity as separate property. In those circumstances, I'm not aware of a case that says that we then go back and pull back out that initial amount that was there, saying, well, that kept its identity even with the commingling. If there is, what's the case?
Well, I think that's what Kiter is saying here. I do think that Kiter is saying you back out what was sitting there before when you know it. There are cases where we don't know it, right? But here we do know it. So I think that, my answer to that question is
Okay.
Kiter, that it requires you to back it out. Now, additionally,
Can I jump in there? If you know it, then it isn't commingled. Isn't that what you said?
exactly, that's exactly right. So what I was
So
getting.
you can't say it's commingled, but we know how much was separate.
Right, because it's a traceability analysis, and commingling requires this traceable, is it inextricably commingled? Well, we know that 1.3 was sitting in there, right? So that's not commingled. And the $100,000 that then came in, I would say, even if we have to look at that as a factual finding, that's also David's separate property. That was money that came from, he had a premarital business with his first wife, Design Coalition. He retired from it when Joanne died, and he dissolved it. He left it intact because he had an employee who was working there. He dissolved it, I think in 2014, I can't remember for sure. And he got back $100,000 of a capital contribution from Design Coalitions. That wasn't money that he earned. That was just a capital
I
contribution.
thought that was 200 grand.
195 was the.
Okay, I thought it was 100. Let's call it 200. That's fine. So that is the amount of money that comes in and gets added in to the money that was sitting.
So it's
In there
separate,
before.
separate upon separate, your argument.
Exactly. So my position is that all of those Morgan Stanley accounts are separate upon separate property. But even if that's not true, the first 1.3 million is clearly separate. I still think you've got a legal analysis on both components, but if that 195, I stand corrected, if that 195 can somehow be, I don't see how it can be marital, but if it is, it's only that part, because the rest is completely traceable.
May I ask you another 30,000-foot question? Let's say we buy some of what you're selling, but not all of it. In that circumstance, we don't reverse, we remand, right? Because then the math is upset. Do you understand my question?
Sure.
And is that the answer?
That you would remand for recalculation.
Right.
Yeah, if, for example, you determined that the Design Coalition capital return could be marital or were marital, then you would have to redo the math. Yes.
Well, no, I think what you'd be having us say would be to send it back to the district court with directions to do a traceability analysis, right? So we'd be asking the district court to do the math.
That's fine.
It-
I think the traceability analysis is, we just laid it out, right? We know what it is, but yes, you would need a new factual finding on the traceability.
I'm going to move on to another topic unless my friends have any questions.
Can I get some more water while you do that?
You bet. As to alimony, the one issue I wanted to ask you about is, it appears that what the district court did is said that Mrs. Krajeski, did I say that?
Krajeski.
Krajeski had a home prior to the marriage in Park City, and then she subsequently sold that. And what it wanted to give her was an ability to basically purchase an equivalent home, moving forward, right?
Equivalent to her premarital home.
Premarital home, that's correct.
Or isn't it, seems like the other argument is equivalent to the marital POA home, but in a different location.
I don't think so, because I don't think that argument was ever made. And the POA home had a mortgage of like $2,000 on it, and it was a huge piece of property. It was a property, not, I mean, its value is in the fact that it's this huge piece of property. She didn't want that. She was very clear she didn't want that. She wanted a house in Park City, and what she said,
I get that. I thought I'd read a statement in the
no, I
briefing
don't
that-
think so.
okay.
I don't think so.
Thank you.
She wanted a premarital house near her family and friends. That was her analysis.
So if you don't agree that is the standard, she's entitled to something for housing, right?
Yes,
And what was your position below on what that amount should have been?
I would say that
Are you
it's,
saying it's the POA mortgage
Exactly.
amount of 2,000?
Yes.
Whatever change?
yes,
Okay.
that would be appropriate.
I think my questions have come to an end. Oh. Nope, that's it. Okay.
All right.
Looks like we're done with questions. We obviously kept you over, so you'll have your full rebuttal time. Thank you.
Good morning, Your Honors. I assume you have some questions for me, but I would like to address the question that was just asked. I do have a different recollection of David's position below regarding Tammy's housing. David's position below was that she needed to just move to St. George and that she had zero for housing. And that was the position all along, that there was zero alimony, that there was zero housing. And the court, because of asking this question, the trial court heard Tammy testify that about her premarital house that she had had, heard her testify as to her roots in, or I'm sorry, her contacts and her life in Park City, and then considered Tammy's estimate of what it would cost to have housing similar to what she had.
Let me ask. You're the chair?
Okay, I'll take the prerogative. One of the things they're telling us on that issue, though, is that if our case law talks about this in terms of the marital standard of living, and it sets something of an anchor or a baseline in terms of what it was that the parties were spending on this particular item, this particular thing during the course of the marriage, then what they're telling us is that it would be folly to award her, as part of the alimony award, an amount to get a Park City home if it exceeds the amount that they were spending on the POA home. What's your response to that?
So I think the situation is a little bit different. David had had that home in Peoa for a long time. There was no evidence as to what a current mortgage would be. He did have an older mortgage, and it was a smaller amount, and they had lived there, and it's a luxurious home on a huge piece of property. And I think the situation was that that's not something that would necessarily be appropriate. Tammy didn't live in Peoa, and she had lived in Park City, and the Park City
But
market
the
is different.
situation that you're describing here is accurate, actually, when you take it down to its roots, is ubiquitous. Parties get married, they live in a home, it's got a mortgage of, let's just pick a number, $2,000 a month. And although I guess in our current economy, that would be nice if we had $2,000 mortgages, but let's just assume we did. And moving forward, clearly, for example, in Utah in the last few years, all homes have appreciated substantially, right? I don't think we have case law that says that what a person gets, I mean, they'll receive some of that if it's a joint asset, they'll receive some of that appreciation, but that's part of the property distribution, not the alimony calculus. The alimony calculus has always focused, at least from my reading, upon the expenditures that the parties were making. Your argument seems to be saying to me, and I want you to tell me why I'm wrong, that if we're looking at what kind of house they had, that a person is entitled to an equivalent lifestyle house, and that we need to give alimony sufficient to go buy one on the open market. Do you have a case that says that?
So I don't think that there's a case necessarily on point with that, but what we are facing, for example, because all I do is divorce work, I'm
Right.
down on the third floor daily, is we're dealing with circumstances. So somebody has to move out of the marital house. They have to move out of the 3,000 square foot marital house and go get an apartment. But the apartment is, because the $2,000 mortgage, but the apartment is $2,500 so that he can have his 3 kids over for parent time. And so an argument, well, you can't have a $2,500 apartment because the mortgage is only $2,000. That shouldn't be the standard, and I don't believe it is the standard, certainly not in practice. And so we have a situation now where the trial court made a determination that in order to have the standard of living, that the dollars might be different. And that, I think, is consistent with the way the statute is written when it talks about, for example, in certain circumstances may equalize the standard of living. And this court has said over and over and over, that doesn't mean you divide the income
But this
equally.
isn't an equalization case.
No. I'm not saying that, but I'm saying that the statute itself talks about the standard of living as opposed to equalizing the money. And so that's what I think the trial court did here, is that the standard of living was pretty luxurious. They had a lot of money, they lived in a beautiful home, and the trial court said in order to sort of have that similar standard of living for Tammy, we need to have this sort of a situation, and it did cost more dollars.
But to be clear, the court wasn't trying to give her an equivalent home to the Peoa home. The
Right.
court specifically said it was giving her an equivalent to the Park City premarital home,
That's correct, that's what the trial court found.
okay? As to the $8,000 figure for the mortgage, what was that assuming was gonna be, is that with a 20% down payment?
So I don't recall exactly the math on that, but it did assume a down payment. There wasn't any, you talked about a property distribution. There wasn't any property distribution to her from the Peoa home. There wasn't any property distribution to her from David's premarital business, because we stipulated that those were premarital. We stipulated that those were not gonna even be discussed at the trial. But she had a limited amount of
Well, what I
assets
wanted,
coming to her.
she had a house before they got married.
Right.
She sold it, right?
Right.
She put that money into an account, did not share that with Mr. Krajeski, correct? What happened to that? If we're gonna tether this to this premarital house, shouldn't part of that analysis include the money plus its accumulated interest over the years of marriage from that as an offset?
And I believe it did. I believe it took into consideration the down payment by using certain of those funds, but the costs of the house itself had gone up so significantly between the time she sold it and the time that she would need to purchase it. And she hasn't been able to purchase it because the trial court then subsequently froze all of the assets. And so Tammy did receive some cash, but has not been able to receive any of the other cash. So she hasn't been able to even effectuate that yet.
You mentioned that what we ought to be doing is looking at the standard of living during the marriage and not whether, even if the dollar amount to get you there is different. What do we do with the idea that the standard of living may be based on the use of separate property? That here the Peoa home was, as I understand it, separate property.
Yes.
And so David contributed separate property both through the use of the Peoa home and infusing separate funds into the marriage to be able to have that higher standard of living. How do we factor that in with what you're saying?
Yeah, so it is true that they lived in his separate property house in Peoa. And it's true that that was their standard of living. It's not true that he was contributing separate funds to their marriage. And because he was only contributing income to the marriage. But the standard of living was based on having that really very nice house. And that, I think, was what the trial court took into consideration of saying, look, you know, to say, okay, well, you just lived in this house, you've had this kind of luxury lifestyle, but now I'm gonna make a determination that you need to live in an apartment somewhere. I think that the trial court exercised her discretion in saying it's more reasonable for you to have a lifestyle similar to what you had during the marriage,
But
and
why-
that's gonna cause this.
Why does she get to make a geography decision, particularly where it so substantially increases the amount that house would cost? I mean, that's what they're telling us in response to the argument you're making now. It's one thing to say, okay, she gets to live in a similar size house, but if her making the decision to live in that kind of house in Park City as opposed to Peoa doubles, triples, or whatever, the amount, why does she get to unilaterally make that decision and have it work backwards into the alimony calculation?
No, and I think that's an excellent question, but the trial court was convinced that because their entire social life basically was in Park City, and Tammy testified that, you know, their social life, their friends, relatives, all of those things were in Park City, and that they would travel from Peoa to Park City to do all of those things, that her life would then be, was based in Park City.
But if during the course of the marriage, and if the linchpin for all of this is the marital standard of living, if in the course of the marriage they're traveling from Peoa to have that social life in Park City, why does she get to put on him the financial burden of her now living in Park City?
And again, I think the trial court was persuaded that it was the most appropriate way of determining what the housing expenses would be. And again, I know that there was some discussion of standard of review, but I think that that's the trial court's discretion to do that.
Can I take you to the standard of review question, unless we want to stay in the
Let's
granular
go there.
level there? You
I
heard,
am not as good as Julie on standard of review. I just will tell you this right now.
well, I'm going to ask you the question anyway,
Okay.
and let you take your crack at it, because it seems like something of the grill in the room on this case. I've not gone as deep down the rabbit hole as Judge Mortensen has, but I've gone mild ways down that rabbit hole, and it does seem like we have case law that says that this commingling determination at its sort of brass tacks level is a question of law that's reviewed for correctness. And it does seem like we also have case law that says that there's this discretionary gloss on virtually everything that a district court does in a divorce case, and that this is part of that. And as I've looked at it, a third of the way down that rabbit hole, I can't make heads or tails of whether the questions we're being asked to answer here on the commingling questions are legal or discretionary, and it feels like on some of them that might matter, and I'm not sure what to do with that. So what's your take on that?
No, I do think that there's a difficulty, but in getting to really the actual nexus of how those things work. I guess I would just look at it this way. I think making the determination of an asset being separate or marital would probably be a legal question, but what happens with that asset would be a factual question. So for example, the premise of their entire legal argument below was that the money that David received from his premarital business that was on their tax returns was separate income. And the trial court made a determination quite clearly that there's no such thing as separate income. And once that legal decision was made, there's no such thing as separate income, and I will indicate there's no case law that says that there's separate income. There's no statutory support for that. Child support statute, it's been renumbered to 81 something, certainly is very broad of what income is for child support purposes, and many courts have said that is the same standard for alimony purposes. So money that's income for them to buy marital assets doesn't become separate by just going in the bank. So once the court made that determination, then the factual determination of what happened with that money I believe was her discretion. And I will tell you that Mr. Kennedy, David's expert, testified that his tracing yielded like 8.4% in one account as marital, but it was premised on the legal argument that that was separate income. And the trial court rejected that. That's why the commingling that the trial court did here is reviewed, or is given deference. And I know that there's probably going to be some allegations that they didn't make that argument, but in their opening brief, they said, but the court decided that various accounts, all premarital in David's name only, became marital because he placed distributions from his separate business, DJK Properties, into those accounts. And that's the money that was on their tax return. And then in their reply brief, they said, on page 6, David earned income from DJK Properties, a business Tammy concedes is David's separate property, and we had stipulated to that. Plainly, the income had to be reported on tax returns, but that does not render it marital. So the legal premise was that there was separate income. And that is why the issue of David's inconsistent testimony came up. And I just quickly want to address that.
Please, yeah.
David filed an affidavit in a motion for temporary orders at the very beginning of the case. And within his affidavit, because that was the strategy for that motion.
And that's where the 20 hours thing comes from.
Correct. He filed an affidavit signed under the penalty of perjury to support a motion that was heard by a commissioner that said, I'm 73 years old and I continue to work 20 hours a week for DJK.
But if it doesn't come up at trial, I mean, maybe I'm tossing a softball here, or maybe it's not, but if it doesn't come up at trial, is it properly part of the court's calculus on that commingling question?
So then the question is, yes, it is. And this is the reason, because the court can take judicial notice of a sworn affidavit that has been filed with the court.
Earlier in the case in a different
Earlier in the
proceeding.
case. And the situation was this. I raised that at closing arguments. Closing arguments are part of the trial.
But they're not evidence, though.
But it's not, but I did point out that he had previously testified to something inconsistent. So if David believed that he could then explain that away, he could have easily asked for the court to reopen evidence on that. And the trial court took judicial notice of the fact that he had made inconsistent testimony and that he had testified that he was working. But I'm going to suggest that it actually doesn't matter because there's no such thing as separate income, whether it's passive or earned. But in this situation.
How would you square that proposition with Brown?
So in Brown, the money that they took out, that he took out, was quintessentially marital. It said that. It says right there. So he receives the money and he puts it in the bank and he spends it. That's marital. That's what happened here. David took the money out, put it in the bank, spent it. And that's exactly what happened here. So putting it in this bank account or that bank account doesn't change the analysis. Once he takes it out, it's income and marital.
But in Brown, it's true, isn't it, that if he earned fees as a dentist and left them in the operating account for the dental business and didn't put them in a joint marital account, doesn't Brown hold that that's remains separate?
And I apologize. My understanding of Brown was that the assertion was that the practice itself became marital due to the one-way flow, and that the panel of Court of Appeals reversed that finding. And I don't know specifically about the dollars in, but again, did Brown report that as income? I don't know. And that's different than, that's what happened here. Is that this money then was on their joint tax returns, and that's what Mr. Townsend, Tammy's expert, testified to. This is the money that was received from DJK and was on the tax returns and went into this bank account.
And why then was Tammy's income from renting her other property not similarly counted as marital?
And again, I don't think it wasn't, and that's the part that I can't seem to wrap my head around. I don't believe that it was found to be separate because the money was used, And so I apologize on that. I don't.
Let me ask you let's get more on that. Let me ask you a different commingling question. I'm not sure this is the 30,000 foot level. This is more of the 10,000 foot level in this case. One of the things that I think the district court relied on in determining that there was commingling was that Mr. Krajeski had used funds from what would have been premarital / separate accounts to fund the party's marital expenses. And the district court, correct me if I'm wrong, but the district court seems to have thought that act functions in a commingling sense. Do I have that right so far?
I don't believe that's the case.
You don't believe that's what the district court said, or you don't believe that's true legally?
I don't believe that's what the district court said.
Because if the district court did say that, then that's a problem under Brown, right? Because we're looking at the flow.
And I agree with that. The flow out doesn't make I've said this for years, that it doesn't change the nature of the corpus,
Okay.
right? But the flow out becomes marital.
Okay, so to the extent that this case turns on, I know there's more than this going on, but to the extent that this case maybe turns on the question of whether funds that were separate get used to fund marital expenses, whether that constitutes commingling, it sounds like you would agree with the position they've taken, which is that doesn't equate to commingling.
If that were the only, if that was the only math,
Yeah.
then I would agree with that. So you have $1,000 here and $10 goes out and $10 goes out and $10 goes out. I agree that the remainder of whatever number I said would be
Right.
separate. But if you go 10 out, 20 in, 30 out, 100 in, which is what was testified by both experts in this case, then that would change it because it's not just a one-way flow.
Okay.
If I have an index fund with $1 million in it before I get married, and then I get married, and during the marriage, that index fund grows because the stock market does good, is the increase income for alimony purposes?
Unrealized?
Yes.
No. Because the statute, the child support statute doesn't talk about unrealized gains.
Design Coalition money, the $195,000. That was separate property? Yes, no?
It existed prior to the marriage, correct?
Okay. When that got put in an account, if there was an account that only contained separate property and the $195,000 is put in that account during the marriage, it retains its character as separate property, correct?
If it is a return on investment, then yes. If it's income, then no.
What was this?
So the trial court made a determination that, and I think she made a determination it was return on investment, but made a determination that the account it went into had already been commingled.
Okay. So back to my question, if we didn't have this soup of commingled funds, but it was separate and it went in there, it would retain its character as separate property, right?
If it didn't go into a previously commingled account, then yes.
Okay, and then the next question, if it does go into a previously commingled account, but we know it's $195,000, why can't just that fact alone make it traceable?
So there's case law on both sides of this question, absolutely. The most famous that I recall is the one where the woman received proceeds from her husband's death in the World Trade Center attack that went into a joint account and then went right out, and the appellate court found that that was just a repository, for sure. But there is also case law that says when you take something that is separate and you put it into a joint account, then it can lose its separate property identity. So the trial court here found that it had lost its separate property identity.
As to the attorney's fees, you would concede, I assume, that it's a discretionary call on attorney's fees. If the trial court applies the wrong standard, that itself constitutes an abuse of discretion, right?
Well, the trial court has determined, well, the decision to award or not award fees is to the discretion of the trial court. And I believe that's pretty straight.
And our case law
In our
says
case law.
that if making that determination, a discretionary call, the court applies the wrong law, that by definition is an abuse of discretion.
I think that's a true statement.
Okay. The court here said that initially, the $50,000 free award granted pre-trial was subject to being paid if the court found that Tammy had the ability to pay. So that's looking at that standard of whether she has the ability to pay and whether the respondent has the ability to cover it. But it appears that when it got down to it, the court said that the reason that it was allowing the fees not to be repaid was because it had decided that the assets were marital. That's not a need-based analysis. Did I misunderstand what the trial court did?
So the need-based analysis occurred at the temporary orders hearing. And the commissioner made a determination that the fees were reasonable and that she had need in order to do that, in order to prosecute the case under Rule 102. The trial court then made a determination that she had that need at that time, and so that's why she wouldn't have to repay it. She didn't award further fees.
You're saying at the end of the case, the court made a finding of need?
Well, I guess the trial court at the end didn't reverse the previous ruling of the existence of need at that time.
Okay.
How, the $50,000, I assume that the attorney fees in total exceeded that?
Yes. Yeah, it's about close to $200,000. And that includes some time for this appeal.
And
We tried this case 3 years ago.
additional attorney fees weren't awarded, just the initial $50,000 award was not
That's
made
correct.
refundable.
That's exactly correct.
Do you have any more questions? Okay,
Great, thank you.
thank you for your argument, appreciate it. Ms. Nelson, rebuttal.
I think I need 4 minutes. I think I get, and I'm definitely gonna need 4.
We tend to be generous with time,
Thank
as you've experienced,
All right, so
but not too generous.
let's start, I suppose, with the alimony. It is,
I'm not gonna be able to take the attorney's fees out of my head.
okay,
Do you want to say anything on the attorney's fees? Was there a finding of need at the front end of the case?
there was not,
Okay. And so your argument would be, there's never been a finding of need?
correct.
And because of that reason, the court misapplied the law, and we have to reverse.
Exactly.
Okay.
To the alimony, it is true that Tammy had a house in St. George, and that what she was asking for was an extra $8,000 a month to fund a second house in Park City near her family and friends. I think we are missing a couple of important things in the conversation. One is Knight. Knight talks, I think Knight helps us with a lot of questions here. First off, it talks about the historical allocation of resources. In the Krajeski marriage, the historical allocation of resources involved about $2,000 a month to pay for the PO property. Perhaps that was the reason that they had money to facilitate other expenses, entertainment, travel, other things. The trial court didn't make any adjustments by saying, well, if you're gonna get a mortgage payment that's 4 times the marital standard of living, we're gonna have to cut down other things. But the historical allocation of resources is really asking, it's a great phrase, it's really asking what the marital standard of living was. How did these people live? And you don't get to just take out one item and say, oh, but actually I need that to be 4 times higher, without it having any other ramifications on anything else. I mean, consider what that would do to an equalization case. That would be a disaster, right? So Knight, I think, tells us about the historical allocation. Knight also answers the question that one of you asked about what do we do when the standard of living is based on separate property. The Knight family was based on separate property. A lot of the Knight family expenses were funded by Jared's family. And Mrs. Knight didn't get the benefit of any of that in her alimony. She asked for it, certainly, and she got no benefit from that. And the health insurance is like an easy example to talk about. The Knight family had paid, they had a high deductible plan, and the Knight family had always paid the HSA contribution, the deductible. So Jared and Rebecca never actually paid that deductible themselves, the Knight family paid it. So Rebecca asked for a health insurance plan where she didn't have a deductible, and this court wouldn't give it to her. The trial court said no, and this court affirmed, saying, no, she only gets what they had, ignoring what the Knight family was paying for. I think Knight solves a lot of our problems here, but we never talked about the Zillow printouts. One of you asked Mr. Johnson whether there was a down payment, and he said he couldn't recall. The reason he doesn't recall is because it wasn't discussed at trial. That's specifically part of our brief. Pages 51 to 52 of our brief talks about how the Zillow documents, they're hearsay. They don't talk about the down payment. They don't talk about the interest rate. They don't talk about anything. But that was exactly the number to the penny that the trial court gave. So I think we've got layer upon layer of error when in that $8,000 award on the house.
All right, we're at zeros, but I think we'll be indulgent on another minute or two, assuming it's responsive to things that came up.
All right, so talking to the income, we've got a very important point, which is that Mr. Johnson's relying on an income statute that analyzes child support and alimony. I am not aware of any case applying that income statute to property distribution. And that's what we're talking about here. Income for purposes of property distribution, there is no reason, policy reason, that statute would apply. Now, Judge Mortenson's question, if I have $1 million invested in the stock market, Mr. Johnson distinguished between unrealized gains and realized gains. If we follow that path, that means if you are independently wealthy and you have money, you better not manage it and you better not use it for the marriage. Otherwise, it will become marital. That cannot possibly be what the law sustains. It doesn't matter whether we're talking about appreciation, dividends, distributions, unrealized or realized. If we say that unrealized versus realized matters or time spent matters, then independently wealthy people will never be able to use their time or use the money that comes off of it. Most of the other questions, I think, go to traceability, which I think we've walked through in our brief. And the last thing that I have written on my paper here, no, I have 2 points. One is that regarding David's testimony, Mr. Johnson said they took judicial notice and Mr. Krajeski should have asked to reopen the evidence. I don't know a case that says you can ask to reopen the evidence during closing argument if they try to take judicial notice after the close of evidence. And they certainly haven't cited one for us to look at. As to some questions that I think Judge Luthi was asking about her income.
Very briefly, we're at zeros.
You're right. Everything that was hers remained separate. Thank you.
Unless there are further questions, in which case we'll stay, but it doesn't look like there are. Thank you both for your arguments. The briefing and arguments in this case have been very helpful. We will do our best to issue a decision as soon as we can. And with that, we'll be adjourned.
Thank you.